A charitable trust is a gift made for the benefit of the public to an indefinite class of people, rather than to an ascertainable beneficiary. Additionally, unlike private trusts, charitable trusts aren't subject to the rule against perpetuities. In the 1951 case Shenandoah Valley National Bank of Winchester v. Taylor, the Virginia Supreme Court of Appeals considered whether a testator's gift to schoolchildren in a will could be considered a valid charitable trust. On April 23, 1949, Charles Henry, a resident of Winchester, Virginia, died testate, or with a will. At the time of his death, Henry didn't have any children or close relatives and was survived by first cousins and other remote heirs-at-law. In his will, Henry named the Shenandoah Valley National Bank of Winchester as executor of his will and trustee of his testamentary trust. In his will, Henry directed that his estate's residue was to be given to his trust. Under the trust, Henry directed that the net income was to be distributed each year before Easter and before Christmas in, quote, as many equal parts as there are children in the first, second, and third grades of the John Kerr School of the city of Winchester, unquote. Further, Henry provided that the income was, quote, to be used by such children in the furtherance of his or her obtainment of an education, unquote. At the time, 458 boys and girls were enrolled at the John Kerr School. Subsequently, Harriet Taylor and others sued Shenandoah Valley, as executor of Henry's will, in the Corporation Court of the City of Winchester to challenge the validity of the testamentary trust. Specifically, Taylor and others argued that the trust created was a private trust that should be declared void under the rule against perpetuities, and that the estate should be distributed to Henry's next of kin. In response, Shenandoah Valley filed a demurrer, or motion to dismiss, arguing that the trust created was a charitable trust, and not subject to the rule against perpetuities, which the court overruled. Shenandoah Valley then appealed to the Virginia Supreme Court of Appeals.